Welcome back. Renowned international lawyer Justice Oagile Key Dingake has become the first nomination to the International Court of Justice from Botswana. Dingake has done extensive work across the globe, having served as the Justice of the Court of Appeal of Seychelles and the High Court of Botswana. He also served as a judge of the Residual Special Court of Sierra Leone and currently sits on the Supreme and National Courts of Papua New Guinea. Now, through his career, Dingake has shown commitment to human rights and the rule of law across diverse common law jurisdictions. He joins us now to tell us more about this nomination and just some of his objectives should he join the bench. Justice, thank you so much for your time and for joining us this morning. First of all, congratulations on that nomination. I'm sure this must be a great milestone for you, particularly in the work that you have done over the years.
Yes, thank you very much. Thank you very much. It's a total honor. The nomination to serve as a judge of the International Court of Justice is a historical moment for Botswana in the sense that it is the first time for Botswana to raise its hand and to say to the world that we too can serve and contribute to the governance system at the highest possible level of the judiciary. So to that extent, it is a historical moment, but it is something that I would like to say it transcends myself, the person called Justice Dingake, in the sense that it does implicate so many dimensions. It speaks to the importance of the rule of law generally, and that the small states, notwithstanding their size, I speak about small relative, the size of a country. And I also probably also talk about small in the sense of a country not wielding that political power like the top global, but still say that we can contribute to the judicial governance through our own, representing Botswana, but also representing Africa.
Certainly.
So I am forged from the fairness of Botswana, a democratic state, a peaceful state, a world leader in democratic dispensation, but I'm also a son of Africa.
You certainly are, Justice, and we were listening to the Minister of Justice, Mameloko Kubai, speaking about just some of the challenges that seemingly persist within the criminal justice system in South Africa. What are some of the similarities that you could compare to what Botswana experiences as a justice system that maybe when you then take it up to a global and international stage, you would be able to bring in solutions for the African continent?
The challenges that face the courts are the same, whether in Botswana or in Africa and globally. What are these? The challenges are the expeditious dispensation of justice in a manner that is impartial, done by independent courts and done competently. So the challenges often are that the rules that govern the mechanics of the court of litigation must be the kind of rules that engender a quicker dispensation of justice. So those same challenges that operate in South Africa, that operate in Botswana, that operate in PNG, where I currently serve, they are the same. So taken to that international level, what it means basically is that the ICJ too must attend to its rules, make them user-friendly, and it must also ensure that its credibility as an independent, impartial, apolitical court is engendered and promoted so that it is viewed as a beacon of justice by the world, in whose hands or in whose jurisdiction each and every country feels that whatever dispute is put on the table will be dealt with impartially, independently, and that the rigor of legal reasoning, the intellectual depth arising out of that court will be such a masterpiece that few can afford to question.
And speaking about that questioning, how do you think the globe views African courts?
Well, I wouldn't say how the globe views the African courts, but having been present in most of the international forums around the rule of law, around democracy, around constitutions, around constitutionalism, I think the challenges are universal. The African courts are still in a place and spot where they are exerting their presence and influence almost at par with the best of the courts internationally.
You have advocated for judicial independence and integrity in so many ways. How do you believe the ICJ needs to uphold and promote these principles, especially in an increasing geopolitical world where there's so many pressures and complex international disputes?
Yes, a good question. I think it's important to depart from this basic fundamental premise. The ICJ is the ultimate judicial organ of the United Nations, deriving its authority from the UN Charter governed by the ICJ statutes. Its location is a sensitive location. And when I speak about its location, I'm not talking about its geographical location in The Hague. I'm speaking about its political, philosophical, and legal location. It is located at an intersection between law and politics. Its decisions and its mandate impact a very sensitive doctrine in international law around the sovereignty of states. You must have heard about the sovereignty of states. Nations are very jealous about their own autonomy and independence. So this is a court mandated to settle disputes not between individuals, but between states. And you would see from a record of the ICJ that some of his decisions are complied with. It's a mixed record, and some of the decisions sometimes are not fully complied with. So that is the nature of the court. So because of its nature, therefore, the judges who must come must be the judges of integrity, of international repute, whose record is beyond question, and who can bring to bear one thing, and one thing only: mastery of international law, fair adjudication, which will earn the trust of every state, small or large, or small or big. So I hope to bring to the ICJ, if Botswana is elevated to that position by the UN General Assembly and the Security Council, because the process of election is a rigorous one. It requires that the UN General Assembly must vote by absolute majority to say yes to the candidate, and the Security Council too must vote by absolute majority, and they should be comfortable that they will elect someone who is independent, whose integrity is beyond reproach, and who can bring respect and credibility to a court at the center of international adjudication.
You speak of sovereignty of states, and there's been this discussion about South Africa and the US, in terms of accusing South Africa of the atrocities against a genocide against white people in the country. What's your take on that positioning of the US in relation to international law?
I wouldn't want to discuss that aspect of what is happening between South Africa and the US. But I can rather just answer your question differently.
Okay.
I hope you wouldn't be unhappy with this. I would rather talk to the same question through the lens of the case of South Africa versus Israel.
Yes, okay.
So in that case of South Africa versus Israel, I think the proceedings were initiated in December 29 of 2023, yes. In which South Africa litigated in a manner that was historic and seeking to enforce the provisions of the 1948 Genocide Convention, and brought an urgent application to the ICJ, which was very interesting. And that result, South Africa partially succeeded because the court did not address the merits of the case, but it did address some of the plausibility of the complaints South Africa brought. Remember, what South Africa was complaining about was that there is some genocidal activity, incitement to genocide that was going on, and there was also the issue of rollout of humanitarian aid. They succeeded in most of those remedies they sought as provisional measures. So in that sense, therefore, and coming back to the US versus South Africa,
Right.
it speaks to the tension in geopolitics. But ultimately, what we must all aim for is that we must have a rules-based international order in which only one thing matters, and that one thing must be law, not force, not warfare.
Justice, before I let you go, just one last question. What message would you have to young African judges, lawyers, people within the legal fraternity, and just in terms of how they need to serve within their countries in order to one day make it onto a global stage?
Yes, when you talk about young lawyers, young judges, I've been lucky. My escort here today is my daughter, Refilwe, a lawyer. And back home is my daughter, Lesedi, a lawyer too. And my son also wants to go into law, the Grand Chief CGA. So, and that also goes on to many young lawyers there.
Right.
That I can mention, and young judges. The message that I want them to carry home with is that irrespective from which corner in the world you come from, whether you come from Bobonong in Botswana, or you come from Ingeleni in Eastern Cape, is there a place like that?
There is.
Or you come from Kunu, the challenges are the same. If you apply yourselves,
Right.
you can still be a player and make your country proud, your continent proud, the world proud, in making sure that the only one principle that matters, justice, is what you carry forward and is what prevails.
And what should prevail. Justice, thank you so much for your time. It certainly has been an absolute honor to get your insights, and we wish you all the best with this nomination and this long, grueling process that you make mention of.
Thank you so much. I appreciate it. Thank you.
Thank you. And that was the international lawyer, Justice Oagile Key Dingake, who is Botswana's first nominee for the ICJ.